Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals. The board is made up of 5 citizens appointed by the Circuit Court. I am Monica Craven, Vice Chairman of the board. Other members tonight are Charles Smith, Terry Russell, and Judy Freshman. Also present is the professional staff, including Zoning Administrator Norma Cozart, Deputy Zoning Administrator Andrew Noxon, who serves as the Secretary to the Board of Zoning Appeals, Cheryl Williams, Planning Technician, and Cliff Hogan, Assistant to the Zoning Administrator. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn off your cell phones or pagers or put them in silent mode. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. 2, we can grant variances from the specific requirements of the zoning ordinance. 3, we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the board shall find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the board must determine that the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and that the character of the district will not be changed by the granting of the variance. A Virginia Supreme Court ruling requires that a variance cannot be granted unless the effect of the zoning ordinance as applied to the piece of property under consideration would, in the absence of a variance, interfere with all reasonable beneficial uses of the property taken as a whole. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff that they have. Next, applicants or the representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room to the right. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient. 5 minutes for applicants for use permits and variances. For appeals, 20 minutes for appellants or their agents. For use permits, variances, and appeals, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the Circuit Court in accordance with state law. On the front table, you will find copies of the staff report for each case before us this evening. We recommend that if you have not yet seen that report for your case, that you get a copy and review it before your case is called. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case, Mr. Knox.
Thank you. Good evening. We're going to go with our 2 deferrals tonight first. Our first case tonight is going to be V-10825-13-VA-1. This is a variance request by Rick Lockhart to permit a 7.5-foot tall fence instead of a maximum height of 7 feet is permitted. This is to maintain an existing 7.5-foot tall fence in its current location along the right side property line. It's in the R6 zoning district on a premises known as 2307 North George Mason Drive.
And the recommendation has changed?
Correct. They wish to defer to the December 10th hearing.
December 10th.
Madam Chairman.
Yes, Mr. Russell.
I move deferral of U10825131 VA1 to December 10th.
Second.
Thank you. It's been moved and seconded. All in favor?
Aye.
Opposed? Abstentions? It passes 4-0. Thank you.
Okay. The next case is the associated use permit, V-10825-13-UP-1. It's a use permit request by Rick Lockhart to permit a setback of 0 feet from the North George Mason Drive right-of-way instead of 25 feet as required. It's to maintain an existing 7.5-foot tall fence in its current location. It's also in the R6 zoning district on a premises known as 2307 North George Mason Drive.
And again, the recommendation is to defer till the December 10th meeting.
Correct.
Is there a motion?
Madam Chairman,
Yes.
I move that the case V10825513 UP1 be deferred to December 10th.
Second.
Moved and seconded. All in favor? Aye. Opposed? Passes 4-0.
Okay.
Next case.
And our first actual case to be heard tonight will be V-10684-12-UP-2. It's a use permit request by Paul Brown to permit a setback of 17.5 feet to the eave and 18.2 feet to the wall of a new one-story addition from the 9th Street North right-of-way instead of 25 feet as required. It's for an existing one-story addition with a garage that was approved by a previous use permit and built in error. This is in the R6 zoning district, premises known as 824 North Fillmore Street.
Board members have any questions of staff? In that case, is the applicant, is Paul Brown? You have a speaker slip that you filled out, correct? But as an applicant, you may just come forward.
I brought with me, I didn't have it at the time that I had submitted my application, but I brought some neighborhood support statements. Should I bring them on up there?
Multiple copies for us? Oh, great.
I can take them all and just pass them.
If you can give one to Mr. Noxon, too. Thank you.
So, yeah, I am Paul Brown, owner of 824 North Fillmore Street. This is not the first time you've seen me, so I appreciate you meeting with me a second time. This submission updates a request I made and was approved by the BZA last July, so July 2012. I certainly had intended to follow, the plan as approved by the BZA at that time. It turns out that there was a discrepancy between the survey plat done by a surveyor and the architecturals done by the architect, which caused the one-story addition and the garage to be built approximately 0.6 feet closer to the street than was planned. And so we're revising for that.
Any questions of the applicant? Okay.
Madam Chair,
Yes, Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10684-12-UP2, subject to the conditions listed in the resolution.
Seconded by Ms. Freshman. Any other discussion? All in favor?
Aye.
Opposed? Carries 4-0.
Thank you very much.
Okay, the next case, this is V-10833-13-VA-1. This is a variance request by Gary Gortenberg and Ann Purcell to permit a main building footprint coverage of 34.5% instead of 33% as required. It's for a new covered front porch with steps. It's in the R6 zoning district on the premises known as 301 North Edgewood Street.
Get the right picture up. We're on Fillmore Street. Need the Edgewood Street. Questions of staff?
Is this the variance
No.
Correct.
proposed for withdrawal?
For withdrawal.
Oh, I'm sorry. I saw use permit come up. My bad.
Use permit that follows.
So the recommendation is to withdraw the subject variance.
Correct.
Okay, is there a motion?
Motion. I move the Board of Zoning Appeals withdraw variance V-10833-13-VA1.
Second.
Moved by Ms. Freshman, seconded by Mr. Russell. All in favor?
Aye.
Aye. Opposed? Carries 4-0.
Okay, now for the associated use permit, this is V-10833-13-UP-1. This is a use permit request by Gary Gortenberg and Ann Purcell to permit a setback of 11 feet to the steps, 15 feet to the eave, and 16 feet to the porch base from the North Edgewood Street right-of-way instead of 25 feet as required. It's for a new covered front porch with steps in the R6 zoning district, premises known as 301 North Edgewood Street.
Questions of staff? I have a question. This whole thing came about because of changes to the zoning ordinance, is that correct?
Correct.
And that's why it's also been deferred several times, is because...
That's correct.
Okay. Mr. Gortenberg?
Hello.
Have any statement you'd like to make? Just,
I think the staff report covers exactly my concerns and addresses it completely, so I won't
okay.
make any other statement unless you feel that you have any questions for me.
Any board members have questions?
Motion. Motion.
Madam Chair, you know how I favor porches,
Yes, I
so
do.
I'd be happy to move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10833-13-UP1, subject to the conditions listed in the staff report.
Moved and seconded. And there are conditions, correct?
Correct.
And you've seen the conditions that are attached. Okay,
Fine with me. Yeah.
super. You're not going to ask to visit the porch once it's constructed like you usually do?
No, well, no.
Don't like our neighborhood?
Well,
The dog's name.
their porch is closer. I like the dog, though. I like the dog.
Good.
It reminds me of the black lab that I have in Detroit.
Okay. Let's take a motion. All in favor?
Aye.
All opposed? Nay? Okay, ayes have it, 4-0.
Thank you very much.
Okay, the next case tonight is V-10844-13-UP-1. This is a use permit request by Joel and Nancy Tavos to permit a setback of 1.9 feet to an existing pergola, hot tub, ground level deck, outdoor grill, and outdoor sink, and 0 feet to a new 6-foot tall fence from the South Greenbrier Street right-of-way instead of 25 feet as required. It's to maintain an existing pergola, hot tub, ground level deck, and an outdoor grill, and also an outdoor sink in their current locations, then to construct a new 6-foot tall fence. This is in the R6 zoning district on the premises known as 5007 Chesterfield Road.
Any questions of staff? Okay, so I have several speaker slips. One is from the applicant and one is from the applicant's agent. Would you all like to both come up? You have statements to make?
Good evening. My name is Matthew Roberts with the law firm of Bean, Kinney & Corman here in Arlington, here on behalf of the applicants Joel and Nancy Tavas. For the board, we have a couple of updated photographs that we'd like to pass up and show you. So once again, my name is Matthew Roberts here on behalf of the applicants. We do want to briefly thank staff for their work on this application. We had hoped for a statement of support, but we certainly do appreciate their input along the way in trying to work with us. As stated by staff, we are requesting a use permit to alter the 25-foot setbacks for a fence, pergola, outdoor grill, and sink in an R6 district. I want to briefly reiterate 2 points that staff has made in their staff report. First and foremost, we do have the support of our neighbors in this application. In your packet, you will find 27 signatures from Claremont residents, as well as a signature page letter in support from the Claremont Civic Association president. Second, there are no zoning violations in this matter, despite the discrepancy between where the pergola exists as opposed to the setbacks as required. We have worked with the county ever since this issue came up, and we've been trying to resolve it, hence the use permit. Staff's concern, as we understand it from the report, is that they do not feel the pergola, grill, and sink are compatible with the surrounding properties given the distance that we're requesting. I think, though, that this problem arises by definition. That is, in the zoning ordinance, in terms of a pergola, there is no definition for that, and staff has traditionally considered that to be a structure. The reason this matters for us and my client is that the distinction between the structure and the building is that a building may be 1 foot from the property line, whereas a structure must meet the 25-foot setback. And I think as the picture is shown, as you can see, this is more akin in some ways to a building than it is what you would think of normally as a structure. There's architectural features here, such as the wisteria, the columns, and then the elements that we've included inside the pergola, the grill, the sink, the hot tub, etc., all make this more of a focal point for the property rather than some standalone structure as you might normally think about it. And similarly with the fence, we would argue the same thing with the fence here. As staff notes in the staff report, our legal access to this lot does not come from Greenbrier where we have frontage, but instead via an access easement on Chesterfield Street. That matters in this case because in our mind, and as you can see from the photos, where this has all been built is effectively in what Mr. Tevaz and his wife have used as their rear yard. Under the zoning ordinance, had this been legally a rear yard, we would be permitted to put up to a 7-foot fence on the rear lot line, as opposed to the 25-foot setback because of the frontage. So given those elements, we would hope that the board would consider it in light of the actual use and the actual way it's been developed. One other issue, and Mr. Tevaz will speak to this more when he comes up to the podium, but in the past and currently we do have some privacy concerns, hence the height of the fence as well as the pergola in its current position. As you can see from the maps that you were provided, this is in fact a cul-de-sac that we back up to. And as anyone who's ever lived in a cul-de-sac might be able to tell you, sometimes people park directly head-on. And as it's developed over time, people have parked head-on. And actually, you can see it right here in the photograph. People have parked head-on right into the backyard, hence the height of the fence, so they cannot be able to see directly into our backyard and the home. So with that, we would certainly urge the board to please consider those elements of the project and grant the use permit. I will now turn the floor over to Mr. Tevaz. Thank you very much for your time.
Ladies and gentlemen, I thank you for your time. This is a property that we bought in 2003. It was a condemned property. You can see on the front page of the historical pictures that I brought for you tonight. It was a turn-of-the-century 1900 farmhouse, the original farmhouse for the whole Claremont area all the way to Skyline. Over the years, that property was partitioned off into bits and pieces. When we bought the property, it was completely ravaged by trees, by vines, by poison ivy, and the county had condemned it. We took it over from the owner at the time and built an appropriate home for my family. Soon after we bought the house and built our property, a builder came in and bought the property about 6 homes behind us and built a subdivision. The lot that you see in between my home and the home next to me was a corner lot in which the builder anticipated building a home for his daughter, which by his plans was going to be as close to my property line as he could have as a side setback. At that point, I was concerned about the privacy on the rear of our property, which was our backyard, which we had established as our personal space. And I felt necessary to build a little bit of privacy, and that's where we came up with the pergola. We wanted to build some trees, a new tree line, and have some vines growing, and I wanted a structure for that. And we built a pergola at that point. We did this in 2005 approximately is when we built it, and it served us well. The only reason it has come up at this stage is because I unfortunately did not pull a permit at the time, not knowing that I needed a permit, and I apologize for that. We had permits for the garage, which you see in the back over here, and when we went through that process, the county and zoning realized that we should have had permits for the pergola, and the process started. So I ask you for the opportunity of keeping this pergola, which I think is inherently a big part of our lifestyle, for one, and also the architecture of the whole home. We enjoy it on a daily basis, and I would hate to have to take it down. In addition to that, my neighbors have been on property. I have support from close to 30 of my neighbors all the way around, and I don't believe there's any objection from anybody. The structure itself is almost invisible from the back side, from the Greenbrier side, because of a tree line that we planted. And we've done everything we can to make our neighborhood and our home in Arlington a nicer place. Thank you.
Questions of the applicant or his agent?
I have a question. The staff report describes alternative recommendations conditioned on certain actions. Have you reviewed those?
I have.
What's your opinion of them?
Ultimately, I would love to be able to keep it as it is. That would be fantastic. If there's modifications that you recommend we do, I would love to hear about them, and I would be, happy to comply as a last effort.
Other questions?
A hot tub looks like it's the cover, but it's below grade, it looks like.
Correct. The hot tub was under permit. There's an existing permit for the hot tub when we built it.
Question of staff. If there was a permit, then why is there a resolution? Why does it even deal with the hot tub and deck?
The permit was actually found after we advertised the hot tub.
Okay.
Our records show two different things on this property. On our CAMA, our regular real estate site, one of them says South Chesterfield Street, one of them says Chesterfield Road. So in our system, the permit didn't show up on the right one. It didn't show up on Chesterfield Road. It was under South Chesterfield Street. That's how we found it late. So there was a permit from, I believe, 2005 for that hot tub.
Okay.
Okay.
Is that the same issue with the deck?
The deck is actually, we wouldn't have needed to have them apply for a permit for the deck because it's grade level. It's about 4 inches off the ground. So the deck is kind of part of the hot tub. It's like a step into it almost, but it's so low we wouldn't require a permit for it anyway, or a setback in that matter.
So the effect of the alternate resolution is actually just they just have those things by permit and by right. It's not.
Correct.
It's not denying them the hot tub and the deck.
We would withdraw those two from either the approval or denial.
Thank you.
Yeah, that's very helpful.
That's a question. Ms. Freshman.
Could you comment on the attorney's discussion about the structure versus the building?
Yes, that is true. In fact, we do treat these as accessory structures, which must meet the buildable area, which is the front and rear 25 feet or side 8 and 10 feet. So this structure has to meet the same setbacks as the house, whereas a detached garage can be as close as 1 foot from a side or rear property line.
Mr. Smith.
Madam Chair, I'm wondering if the applicant, let me see, the address, the home through which you gain access to your property is occupied by whom?
He's asking who your neighbor is.
I have multiple neighbors.
Only one that you traverse to get to your property.
5011 Chesterfield.
He has an easement up front.
Who is that easement with?
And that would be, his name is Jose. And you will find his signature.
That's my next question.
His signature might not be on your paperwork because we have additional signatures after this was sent to Andrew. Yes, right here. Last signature.
Okay.
Okay. We can, this is for us?
Well,
This is my original. Do you want-
you don't, because you can't have it back, so, right? Unless you have.
Those
you don't have
signatures
copies.
are in your packet.
Oh, they are?
Yes, yes.
Everything else is just
That-
not.
There's some additional ones.
They're additional. Oh, I see. I'm sorry, I misunderstood. After the
Could,
fact.
maybe, I forgot your name, the
Matthew.
counsel. Matthew
Matthew Roberts, yes, sir.
Roberts?
Yes, sir.
Mr. Roberts, maybe Mr. Roberts can run up to his office and make a copy of that, and, because it would be helpful for the record to have the neighbor who is, I think, from my point of view, most directly affected, have his signature on file in the case as supporting your request for the use permit.
Absolutely. I was in fact just about to suggest the same.
Seems to me they could provide it tomorrow.
Yeah.
Or a
Yeah,
copy to
yeah.
staff, that's fine.
Yeah,
But
yeah.
who's gonna get
As
it?
long as it's provided, in the file, I just needed to know that that had been accomplished. Because I think you have a very difficult lot, without question. And my basic view is that I'm not disturbed by the pergola placement at all, or the things that are inside of it. And I'm not so disturbed by the fence either. One of the photographs seems to show some damage that had occurred as a result of a tree limb that had fallen on it. Is that on the side or on the back?
This is the Greenbrier view to the
Right.
rear of my home.
Right, I'm wondering about these photographs that were provided to us that show a tree intersecting.
So, on the back end, where the pergola is, there were 3 big maples that were 60 years old. After the construction and the disruption of the root system, I believe that they eventually died. So we had, one of them fell over the fence and broke it.
Okay.
And then.
Where did it break the fence?
I'm sorry?
Where did it break the fence?
Right in the middle section behind the grill, actually.
Okay, okay. I mean, you don't really see a pergola at all from this point of view in the summer with the wisteria having grown in.
You really just see the fence.
You really just see the fence. And if I were in your shoes, I'd want a fence there too. Okay. Those are my feelings on this
Any other
request, Madam Chair.
questions or comments? Are we ready for a motion?
I'd be happy to try one.
Okay.
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit for for the pergola and fence and the kitchen that includes it, the alternative resolution.
That permits the 1.9 feet to the existing pergola, outdoor grill, and outdoor sink, and 0 feet to the...
6-foot-tall fence from South Greenbrier Street right away instead of 25 feet as required by Article 3 of the zoning ordinance. with the conditions that are usually described that usually are included in a staff report.
There seems to be conditions at the bottom of the alternative resolution.
Okay. Yep. Agrees to it not be built over or enlarged, that it remains, it's already constructed, so that it remains in the, I would say remains in the condition in which it's found at this time, which are reflected in the staff report dated November 8, 2013, and that you agree that it won't be enclosed and obtain any building permits that are required.
So the motion is for the alternative resolution with the attached conditions. Is there a second?
Second.
Any more discussion? Ms. Freshman?
I do have a comment. I find it a little bit disturbing that the ordinance is such that we can have a debate like this about structure versus a building, which adds to the confusion and I think probably should be addressed. But I also, I'm uncomfortable because this is another example of applicants who have to come in to try to make non-conforming conforming because they didn't know or try to know what the regulations were. So I think that's just an unfortunate position that you're in, but it also is an unfortunate position for us because if we have a situation in which we say, oh, well, somebody didn't know or didn't try to know what they were supposed to do, and now there's this wonderful structure or whatever it is, that would be really a shame to have to tear down or very costly to do so. It puts us in an untenable position too. So I just find that more and more we're seeing examples of this, and ignorance is no excuse. So I just needed to say that I'm a little uncomfortable with the continuing issues such as we're seeing in this application.
Any other comments? Just personally, because of the lot siting with the Greenbrier behind it, I think that if this were to come to us as a use permit, we would be approving it because of the odd siting. So because of that reason, I'd support it. So let's take a vote. All in favor? Aye.
Aye.
Opposed? No. Carries 3-1.
Thank you.
Thanks very much.
Next case.
Okay, the next case tonight is V-10847-13-UP-1. It's a use permit request by Lauren and Carolyn Gilbert to permit a setback of 1 foot to the eave and 2 feet to the wall of a new one-story detached accessory building from the rear property line instead of 10 feet as required. It's for a new one-story detached garage. This is in the R6 zoning district. The premise is known as 415 North Kensington Street.
Questions of staff?
Yes, I did have a question. I thought that when we heard this case before, that the general consensus was that putting the garage in the back corner was a good idea. And given that that appears to be what's proposed, I'm confused by the recommendation.
That was the general consensus of the board, but it's not staff.
There is that. I get it.
We think that there is a by right option where they can place it and, still have enough yard, and so that's our stance on this.
Thank you.
Thank you. Mr. Gilbert, Ms. Gilbert here. And you probably rather confused too, as...
No, that's all right. Drew does a very thorough job, so I can't fault him for that. As we talked before, the reason we talked about placing it there was just to provide a little bit more backyard space. As it is now, if we were to place it where current zoning allows, it gives me 10 feet on one side of the driveway and 12 feet on the other side. I tried to talk to the neighbor on the Kensington side a couple times, and they didn't come to the door, even though I knew they were home. Probably thought I was selling something. The Fifth Street side was fully supportive of it. There's actually 3 sheds back there right now, 2 on the Fifth Street neighbor side and 1 on this current property that constitute kind of that back corner. There is also a fence that's about 6 feet tall on on the Kensington on the by the 5th Street neighbor. So with the garage being placed there, and it's a slight slope up the hill, you're really only going to see a couple more feet of the roof than if it was 8 feet farther back. But other than that, we talked about it all a few weeks ago.
Exactly. And there's a speaker slip for Armando Beguera.
Good evening.
Good evening.
As I have addressed the last time that I was here, I was more concerned about the trees in the neighborhood and in Arlington in general. We see that through the development of new houses, trees are being removed, and that changed in a way the character of the Arlington County. And I know that in the near future there's going to be another house which is going to be for sale, number 5710, has a beautiful oak tree. And I'm pretty sure if they're going to put 2 houses in that lot, they're going to knock that tree out.
And do you have a particular problem with this spot in there?
Not at all.
Okay, all right. Just in general?
Trees have been removed already.
Okay, exactly. And for the record, your address is 500 North Kensington?
Yes.
Thank you. Any questions of applicant or speaker? Motion?
Madam Chairman?
Mr. Olson?
I have a question of the staff, just so that I'm looking at the plat and confusing myself, which is usual. Let me find the plat again. What I see, and maybe I'm reading something wrong, this garage is 23 feet from the right-of-way.
It's 28.
That's a 28?
Correct.
I see. It's small for my old eyes. It's 28. I thought it was 20, and then I thought it didn't match up very well with 29.9, but I didn't have the presence of mind to leap to that was an 8 rather than a 3, because my point would be that the house behind them, fronting on Kensington, if properly placed, not properly, that's incorrect, but placed at the setback would be 25 feet back. So
Correct.
this is, it's 29. So this garage in this location actually lines up with the house behind you. It seems to me that behind them, but so I mean, that it's, and a point that I've made on these is that the house next to them on Kensington Street, which is an interior lot, could have a garage in this almost exact location. So again, corner lots, which maybe we should outlaw. Since we, or it would be nice to figure out some way to deal with corner lots administratively, I think.
No.
But anyway, so that's that allays some of my concerns about approving a garage at whatever it is, 1 foot or so, rather than at 10, as required by the ordinance.
Okay.
And with that, I'll make a motion to adopt the alternative resolution granting the use permit request to permit a setback of 1 foot to the even 2 feet to the wall of a new 1-story detached accessory building from the rear property line instead of 10 feet as required for a new 1-story garage subject to the conditions in the alternative resolution.
Second.
Any further discussion? All in favor?
Aye.
Opposed? Carries 4-0. Hope you enjoy your garage in the corner of your property. Thank you. Next case.
Next case tonight is V-10848-13-UP-1. It's a use permit request by Shar and Raphael Roman to permit a setback of 19 feet to 2 window wells and 23 feet to the wall of the existing home from the Second Road North right-of-way instead of 25 feet as required. It's for 2 new right side egress window wells and the vertical expansion of a basement. This is in the R6 zoning district, premises known as 225 North Jackson Street.
Questions of staff?
Am I correct in understanding that this is simply for the window wells in order to make the windows large enough for the access required by the building code in order to use the space?
Correct. To use it as a living space.
They are at grade.
That's correct.
Applicant, Mr. Roman, present? Or Mrs. Roman? Oh, lots of Romans.
She's not a Roman. I'm the architect. She's the architect.
Someone like to make a statement?
I mean, well, we thank the staff for the work that they've done and certainly agree with their recommendation. We've lived in our home since '98, and we love Arlington. Our kids are obviously in elementary school here, so we want to stay in the home. We want to create more space for them to hang out, and obviously the big part of having egress windows is to have a way to get out of the basement safely. So, I mean, that's sort of really what we're here today for.
Okay. Questions of applicant? Questions of the architect? Ready for a motion?
Madam Chair?
Yes.
I'll be happy to make a motion to approve that I'd move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10848-13-UP1, subject to conditions listed in the resolution.
Moved by Mr. Smith, seconded by Ms. Freshman. All in favor?
Aye.
Opposed? Carries 4-0. Thank you.
Our next case is V-10849-13-UP-1. It's a use permit request by David and Jennifer Schmidt. Permit a setback of 18.8 feet to the steps from the South Barton Street right-of-way instead of 25 feet as required. This is for reconstructed front steps on their porch. It's in the R6 zoning district on the premises known as 807 South Barton Street.
Questions of staff? Clarification, this is just to reconstruct an existing stairway, not making any changes to the location or anything. Excuse me. Mr. and Ms. Schmidt here? Good evening.
Good evening. To answer your question, so what we're trying to do, I don't know if you can tell in the picture here, the stairs are uneven, and the last step up onto the porch is, I forget the exact, it's like 3 or 4 inches higher than the other steps. So when people come up the steps, they get used to the first couple being whatever height they are, and then they trip over the last one. So all we're trying to do is build stairs of uniform height going up to the front porch. I think in order to do that, we needed to add one additional step. Otherwise, the rise of each step would be above code. So all we're trying to do is make the minimal change we can to this in order to get the steps to be a reasonable height and uniform.
And the brick sidewalls are staying, it's just the steps.
Those are leaving. We're going to put railings in instead that match the white railing that you see off to the right in this picture on the rest of the porch.
Okay. Questions of applicant?
Well, one, Madam Chair, it looks like this is part of a bigger renovation that you're doing at the same time.
That's correct.
Okay.
Okay. Ready for a motion?
Yep. I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10849-13-UP1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Freshman, seconded by Mr. Smith. All in favor?
Aye.
Aye. Opposed? Carries 4-0.
I know it's a little late, Madam Chair, but just to be clear, I'd like to ask staff, had they sought to just replace the stairs exactly as they were, they're non-conforming, would they have had to sought a use permit for that?
They would.
Okay.
Complete replacement, yes.
Oh, wow.
If these were like deck stairs and they just need to replace the floorboards but don't touch the actual structural members, they could do that by right.
Thank you.
Thank you.
Next case.
And, thank you. It's a speaker slip that just came in. Our next case is V-10850-13-UP-1. It's a use permit request by Paul Weinshank and Jennifer Bloom to permit a setback of 5.3 feet from the right side property line instead of 8 feet as required. This is to maintain the location of an existing grill and fireplace with a chimney. This is in the R10 zoning district on the premises known as 3081 North Oakland Street.
Questions of staff? Okay, Mr. Weinshank?
Hi, good evening, and thank you for the opportunity to speak. I'm afraid we fall into that camp of people who probably should have known, unfortunately missed it. We spent a lot of time over a number of years working on the idea of building this grill, got waylaid by the derecho and a whole bunch of reconstruction of our home, but finally this summer got this thing complete, only to discover literally as the last bit of work was being done that we had built it inside of our setback by about 2 feet 7 inches. The sad thing for us is that it didn't matter. We could easily have accommodated it in the room that we've got. We've got a comfortable backyard, and the utility of the grill to us would not have been impacted in any way at all. So unfortunately, we didn't, and we've pursued the use permit, and certainly are very happy to have Mr. Noxon's recommendation. And as he notes in the material that he's prepared this evening, we satisfy the requirements for the issuance of a use permit and ask for your positive consideration of our request. In the alternative, we're looking at a pretty expensive fix here, or more sadly, a demolition. Happy to answer any questions.
Any questions of the applicant?
Well, Madam Chair, a couple of questions. Because initially when I saw it, I thought safety, like your concern number 3 of your neighbor. Not smoke, but I thought embers. So my first question is, was this constructed by a construction company?
It was.
Familiar with chimneys and outdoor grills and the like?
I would say yes. I know that they have built others, not this exact identical design, but others that are similar.
Okay. That's it right now, Madam Chair.
I see that neighbor on one side, 3101, signed the petition, but I don't see 3073.
Yes, that's correct. The neighbor to our right in this photograph, the neighbor who abuts the side of our property closest to this grill, was the individual who raised the question with county staff. So after we had confirmed with staff that there might be an issue, and had come down here to the county office building, I visited with her one evening, and she essentially raised a couple of concerns. One was that she was worried about visibility from her sun porch. The sun porch that she has, the side that actually has windows facing our lot, has frosted glass. So when you're in her sun porch, you can't actually see my yard, this grill. You can't even see her own yard. And we opened the door, went out and looked, and you could see sort of the top of the grill over our fence. And I've suggested happily that we would build an opaque fence through there, or put in additional landscaping to address that issue. really very, very small scale sort of imposition, if you will. She also raised concern about a spotlight that was installed on a corner of our house closest to her home. That spotlight had actually gone up last fall when we were rebuilding the house after the storm damage. She was concerned that she was getting some light coming through the frosted glass into her sun porch. So we waited until it was dark, and I turned on the light, came back, we looked at it, and I could get a sense for what she was talking about, and put a ladder up on the side of the house that evening, adjusted the spotlight, went back to her house, and we looked at it again, and she said, yep, great, took care of that issue. The last issue she flagged was that she was concerned about smoke from the grill. And I certainly understand that, like any of the chimneys in my neighborhood, we have a chimney in our living room, and it's wood burning, and many of our neighbors still use wood burning fireplaces. Smoke will travel, and it will travel where the wind takes it, and whether the grill was where it is or 2.7 feet to the left to be purely out of the easement area, not really going to have an impact. The reality, too, is that the grill faces the interior of our lot, so sort of the chimney area is facing our place as opposed to facing one of our neighbors. I did ask her as we kind of talked through these things and had our conversations about whether she would be willing to support the application. She told me that she would not, but that she would not be in opposition to it, and to my knowledge has not expressed any opposition. And looking around the room here this evening, I don't see her.
No speaker slip from her now. Any other questions, comments from the board?
Madam Chairman,
Yes, Mr. Russell.
in terms of the fire issues, it seems to me that, the quality that this construction appears to be is very similar to an indoor chimney fireplace, or one that might be built outdoor or semi-outdoor by being located on a porch, which is becoming more common these days. Forgetting to just dealing with the fire issue, not the placement issue. And that I'm not going to ask staff to rule on this, but I wonder if you might have a fire pit in your backyard that's not as structurally enclosed as this. I mean, it's just a hole in the ground that you throw wood in. And, I don't know what the fire marshal's position is on that, but people have them all over. So I'm not as concerned about the fire issue, particularly if this could be located as a matter of right 2 feet over. That's, now with leaves on the ground right now, maybe we should all be more concerned. But that's, again, this is similar to the one we had before with the structure built without a permit, and a couple of feet, or the other one was more severely in the setback than this is. And let me also ask a question of the staff. You talk about several things being 5 feet. What is the regulation?
This is the same thing as that pergola. It's an accessory structure, so it must be at least 8 feet from the side, or 25 feet from the rear.
Talking about the 5, you all have supported recommending of a use permit variance to 5 feet, but not to this far.
Well, this is more than 5 feet. We've recommended as close as 5 feet.
Okay.
Madam Chair, my concern about the fire, I think Mr. Russell is absolutely right, that a little less than 3 feet is not going to make a world of difference if there are embers flying about. Part of my concern was was alleviated by the fact that it was constructed by a professional outfit that has experience building such structures. I think inherent in any open fire is the risk of it moving, whether it be in a fire pit, a firebox, or an outdoor chimney, if you will. So I don't want to minimize the risk or my concern, but at the same time, it doesn't prevent me from seeing, really from agreeing with, or it doesn't put me in a position of disagreeing with the staff's recommendation.
Okay.
The fact that the neighbor is not here, though she did express some concern, which you, sounds like, tried to work with her on, is helpful. So I'm not going to stand in opposition.
Okay. Is that a motion? Is there a motion, Mr. Freshman?
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10850-13-UP1, subject to the conditions listed in the resolution.
Second.
Moved and seconded. All in favor?
Aye.
Opposed? Carries 4-0.
Thank you very much.
Welcome.
Our next case tonight is V-10851-13-UP-1. This is a use permit request by Donna and Charles Sullivan to permit a setback of 2.5 feet to the eave and 3 feet to the wall of a shed from the rear property line instead of 10 feet as required. It's for a new detached storage shed. This is in the R6 zoning district on a premises known as 2901 22nd Street North, and this is actually in the Maywood Neighborhood Historic District as well.
Questions of staff? Are Mr. and Mrs. or Mrs. Sullivan present?
Thank you to the committee. Thank you to the staff for your work. At this point, we don't have any outdoor building for tools, bikes, and other things that we need. And we're fairly limited with placement. It's another corner lot issue. We're asking that we be allowed to place this in the corner of the yard and not in the middle of the yard that we're currently using for a sitting space. So we don't have a problem, as I understand, for setback to be close to the inner lot, but it's the variance we're seeking is from the back fence to go 3 feet within that our new fence instead of the 10-foot setback. The 10-foot setback would be a lot of wasted space, and again, we're trying to keep the shed away from the sitting area, away from our neighbor's deck on the interior lot. And we do have letters of support from both neighbors.
Questions of the applicant? The trees in this picture will remain, I assume?
They will, yes. We need to take out one sapling and one azalea, but otherwise be placed between the old oaks. And far enough that the root system shouldn't be affected either.
Question? Comment?
Madam Chair, it's a substandard size lot, both in width and area, and the placement has been condoned by the Historic Review Board. So I'd be happy to move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-10851-13-UP1, subject to the conditions listed in the resolution.
Seconded by Ms. Freshman. All in favor?
Aye.
Aye.
Opposed? Carries 4-0.
Thank you.
You're welcome.
All right, the next case is number V-10852-13-UP-1. This is a use permit request by Julie and Matt Carey to permit a setback of 6.5 feet to the porch base from the right side property line instead of 10 feet as required. Also, an aggregate side yard of 15.3 feet instead of 18 feet is required. This is for an enlarged wraparound front porch. It's in the R6 zoning district on the premises known as 1825 North Dinwiddie Street.
Questions of staff? Are Julie or Matt Carey present? No applicant? Is there a representative of the applicant? Okay.
Madam Chairman?
Mr. Russell?
Question of staff.
Yes.
Is this wraparound piece to this porch the only construction going on this property at this time?
That's correct. Mm-hmm.
So the house has been built, it's been thought, well, porch would be better if we wrap it around the side a little bit. Thank you.
I think they really wanted to do something with that flat wall they have on the side where it's pretty much vinyl siding the whole way down.
And would it be, is it 6.5 rather than 10? Yeah, never mind. Thanks.
Well, and pshaw to those folk who say that you can't have a porch that's only 6 feet deep.
True.
Usually folk argue, well, it can't be any smaller than 8 feet to be comfortable, to be able to move around, to put my rocker or whatever. I think it could be accomplished with less, and these folk are proving that. Mr. Noxon, if I might, Madam Chair.
Please.
Have you had any communication with them about their attendance tonight?
I have not. I actually haven't heard from them in quite a while, about a couple weeks. So.
You said a week?
A couple weeks.
Oh, a couple weeks, okay.
Madam Chairman, another question.
Yes, Mr. Russell.
I'm trying to figure out, do we have a recommendation of approval from 1821?
It's the back cover.
Thank you.
I looked for that, too.
The same thing.
Well, in their absence, shall we go ahead and discuss this and vote on it?
I, for one, don't have a problem with
Yeah, I, for two, don't have a problem with it.
But you for three.
If they've changed their mind about it, they don't have to pursue it. They've already paid their fee and it's gone to hearing, so.
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10852-13-UP1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Freshman, seconded by Mr. Russell. All in favor?
Aye.
Aye.
Opposed? Carries 4-0. We're going to wait for them to come and find out if it was approved or not.
I'm sure.
You can pull their leg, too, in the process.
You wouldn't believe it. People do wait till the last minute. We had one come in today expecting to pull a permit today because it expired today. So it's happened. Luckily, his was just a bay window, and that's all. So
Wow. All right. Next case.
our next case is V-10853-13-UP-1. This is a use permit request by Michael and Tung Mullen to permit a setback of 4.9 feet to the eave and 5.9 feet to the wall of the porch from the right side property line instead of 10 feet as required. It's for a new rear screen porch with a rooftop balcony. This is in the R6 zoning district, premises known as 824 25th Street South.
Questions of staff? Mr. Mullen?
Nothing really to add. He addressed everything in the report here.
Okay. Any questions of applicant? You've seen the conditions?
Yes.
That are, okay. And you have no problem with that?
Problem.
Questions, comments? Motion?
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10853-13-UP1, subject to the conditions listed in the resolution.
Second.
All in favor?
Aye.
Opposed? That is one beautiful,
That's a nice,
isn't that?
the backyard looks
that
very
looks
nice.
so
I love
nice.
the way that's done.
Okay, passes 4-0. Next case.
Okay, our next case tonight is V-10854-13-UP-1. This is a use permit request by Larkspur 19th Street LLC to permit a setback of 2.7 feet to the eve from the right side property line instead of 8 feet as required. Also a setback of 10.6 feet to the eve from the rear property line instead of 25 feet as required. Then also an aggregate side yard of 14 feet instead of 18 feet as required. This is for a new eave overhang for a new 2.5-story addition above the existing main building footprint. It's in the R6 zoning district, premises known as 3207 19th Street North.
Questions of staff? And
Looks like you've tweaked, Madam Chair, if I might, it looks like, Mr. Noxon, you've tweaked their requests and inched it back a little bit. They want 2.7 feet. You're willing to go with 3.7.
And that would give them a 1-foot eve instead of 2.
Yeah, and a foot, yeah, a 1 foot eve instead of 2, essentially. Okay.
I have a speaker slip for Stephen Bartel. Are you the agent for Larkspur?
No, I'm Paul Brown, the applicant.
Oh, you're the applicant. Oh, I'm sorry. It just says Larkspur. I did not see that there was an applicant. We already had a Paul Brown tonight.
I know. I saw that. I thought I was
Says,
first.
I guess,
He was first on the agenda. I thought, all right.
the signature, when you look at the
I saw
application,
that.
it says
Yep.
Paul Brown. However, the owner's name is Larkspur 19th Street LLC.
That's correct.
You're the managing.
I'm the managing member of Larkspur, 19th Street LLC.
Brown ends with an E in this case, where it did not in our first applicant. Would you like to make a statement for us?
I would. We have, I have purchased this property with the intention of substantially renovating it, and I don't know if the nomenclature is accurate, but I think of it as a 1.5-story house now, and I propose to convert it to a 2-story house. So I think of it as a half-story addition rather than a 1.5-story addition, but that's, be that as it may. We're proposing to construct the house or the renovation in arts and crafts style, in which prominent eaves and low roof slopes are typical. So we feel very strongly we chose 2-foot eaves for a reason, and we hope that the board might grant us that. At the risk of shooting myself in the foot, I will go ahead and say that you will notice that there is a discrepancy between our plan and our elevations. Elevations all indicate that the eaves will extend 2 feet on all sides. But the plan does not indicate that the projection out on the left side would have eaves around it. So even though that would be on that side, it's a little hard to read, but the closest point is 11.3 feet on that left side, and so that would be reduced, proposed to be reduced to 9.3 feet with the eave. So that means that the aggregate side yard as proposed in the proposed resolution is not correct, but it's, the board might allow that, given that the elevations clearly indicate that those, the 2-foot projections were called for.
In this case, you would be covered because of the aggregate. The eaves are allowed to project into that. Therefore, we don't consider that side that's by right as part of that aggregate, only the side that's closer than the 5 feet that you're allowed to go with an eave overhang.
That's what I had hoped would be the answer, but then I did not understand why there would be a a requirement or something in the resolution about the rear yard, since, as I understand, these could project by right into the rear yard, even though it is currently non-conforming in that the rear yard is less than 25 feet.
Well, see, the stipulation is you can project 4 feet into any setback, but no closer than 5 feet on any side. So that only works on the 8-foot side. You can get as close as 5 feet, but on that 25 rear, you can only go to the 21 mark. That's your 4-foot encroachment into the setback. That's why that's advertised as is.
Well, okay. Very well, thank you. I did not understand that, but we are proposing what we are, which is a 2-foot eve on all sides. And I would ask your approval.
Are you keeping the tile roof?
That would be mission style if you kept.
That's right.
Yeah, I guess so.
And it's got to be shingled or.
Shingled. It's going to be we're proposing, it's a little hard to tell from the drawings, but there'll be brick with cedar shingles above and shingle roof.
Yeah, part of it, it looks like the half story is really the craftsman.
That's correct.
Part.
That's correct.
Okay. But it's not going to remain white, is it?
No, it's not.
That would not be craftsman either.
No, indeed.
Wow.
Okay, all right.
So we have a speaker slip for Stephen Bartel. Good evening.
This is probably rather unusual, but I came here with the intention of strongly opposing this application. That's because I had not seen the plans, and I live at 3208 19th Road, which is the house directly behind. We share the backyard fence. When I just got the notice in the mail, I read it as there was going to be a tremendous difference from the 25-foot requirement backing right up to much closer to our backyard. Having reviewed the plans for the first time tonight, I see the builder plans to use the same footprint. So I actually, you'll see on my speaker list, changed my opposition to support for the plan. And so since I'm here anyway, I thought I would just come forward.
Well, thank you.
And let you know that.
We appreciate that.
Madam Chair, you might want to initial the back because there was a space provided for your approval, both acknowledgement of receipt and then approval and the date.
I would be happy
At the
to
top
do
of the
that.
list.
I am on top of the list. I like that. However, I never received the packet.
Right.
It was never, and if it was brought to our house, we never saw it. It may have been misplaced. I don't know. But so I never saw it until I was sitting here tonight. And again, reviewing it, it actually looks like it'll be a nice development in our neighborhood.
Terrific. Thank
Interesting.
You. Questions, comments?
No, I'm not going to open up the can of worms and ask Mr. Brown how that might have happened.
Well, I don't know. I personally hand-delivered packages of drawings to every house within the radius on 19th Street as well as 19th Road. And I sent letters as well saying that I was going to stop by. So I do not know how it happened, but I'm glad Mr. Bartel came here.
Your neighbor, and everything will be great.
It's good that it starts like this instead of the other way, but thank you.
Exactly. Terrific. Motion?
Madam Chair.
Mr. Smith.
Let's see here. I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10854-13-UP1, subject to the conditions listed in the resolution. And I presume what I'm moving to support is the request of the applicant.
That would be the alternative.
The alternative motion.
Okay, so the alternative resolution with the conditions is the motion on the floor. Okay. And Ms. Freshman, you seconded it? Yes. Okay. Any more discussion? All in favor?
Aye.
Opposed? Carries 4-0.
Okay, our final case tonight is number V-10855-13-UP-1. This is a use permit request by Bobby Joe Pankaj to permit a setback of 14 feet to the eave, 15 feet to the porch base, and 20 feet to the eave and 21 feet to the wall of a new 2.5-story home from the North Nottingham Street right-of-way instead of 25 feet as required. And this is for a new 2.5-story detached single-family home with a covered front porch and steps. This is in the R6 zoning district on the premises known as 1906 North Nottingham Street.
Questions of staff? Is the applicant, Bobby Joe Pankaj, here?
Good evening. I'm Arun Pankaj. This is my wife, Bobby Joe. We're the owners of 1906 North Nottingham. I want to thank Mr. Noxon for his hard work, and we concur with all of his analysis. I'd just like to point out that we're asking for basically 10 feet from the front setback. Given the large right-of-way for the county that you can see on the North Nottingham Street side, this would still put us about 35 feet from the curb, even with this addition. Of the 10 feet, we're asking 4 feet for living space and a 6-foot porch. If you can see the existing house layout, we're actually making a significant improvement to the safety of the houses around it. Right now, the existing structure is only 2.3 feet from the adjacent property, and we're going to move that to 8 feet. As far as compatibility goes, the current structure is kind of sitting in a hole. It's very far back from the street. It's not really part of the neighborhood. And the driveway has this, metal rails around it that doesn't really fit in with the rest of the neighborhood. So we think with this new structure, it will be much more compatible with the other neighbors. And we've done quite a bit of community outreach. We've talked to the majority of our neighbors, gotten a lot of support from them. Talked to the Civic Association as well, and they didn't have any objections to our request. We're subject to any of your questions.
Any questions of that? There are several speaker slips. Pamela Thompson, and then Michael Schnitzer.
Good evening, and thank you for this time. I own the property at 6011 North 19th Road, which is 2 houses down from the 1906 Nottingham property. I don't object to them tearing down the house and building up. My concern is that that house is higher in elevation than my property, and as well as my property is lower than 607. So the water runoff is quite substantial, and I've tried to take steps to make sure that it doesn't pool in my yard, but it still does. And so my concern is that they are expanding the footprint of the house, which I'm concerned about will increase the runoff into my property.
Question?
Can you address that, a runoff question?
About the footprint size or the runoff? The runoff?
The runoff question.
It's true. There is a significant slope on this lot. I'm not an expert in stormwater management practices, but I know that we have recently revised our stormwater runoff treatment that's required for people when they build new homes in the county. You're required to treat all your stormwater on site with planting beds that are fed by your gutters. So that should take care of a lot of the runoff from the actual home. Other than that, whatever happens from the land, DES may have requirements when they submit grading plans for the new house as to where the runoff can go on the property. So they'll be pretty restrictive on what can happen with that water runoff onto other properties from this.
And so you're under that scenario, we can assume that the restrictions are tighter than for what is there at present.
Correct.
And that they would be required. Is it necessary for us to condition that, or do we believe that the
They're
zoning
required.
regulations are already required?
They're required by disturbing 2,500 square feet. They have to do grading plans and do stormwater treatment and that such thing.
Thank you.
Which is good to hear, because I know in the past that there have been problems on certain lots, so that would be very comforting if I were you to know that there will be plans required. Now, when those grading plans, are those done privately? Will that be a public notice?
That's part of the building permit process, so they just have to submit their grading plans, and those are done by a professional civil engineer.
And I would suggest that you all keep in touch with Ms. Thompson, especially when that occurs, so that she can see what they're doing and feel some.
I hope so, because it is quite a difference in grade.
And she can also certainly go down to the Department of Environmental Services and just speak with them when the permit plans are in, and voice her concerns to them, and they can give her some sort of assurance that I can't give you at this point, and not being environmental services staff. So.
Well, does that come before or during this permit process?
They can't start any construction until they submit those grading plans and they're approved.
Okay, the grading plans, so I need
Exactly.
to contact them just to make sure.
Correct.
Okay, thank you.
Right, and the applicant can certainly.
Madam Chairman?
Yes.
In
Mr. Russell.
in this particular instance, because of the scale of the change that they're making, all of these administrative functions under building code and Department of Environmental Services code go into effect. And in fact, someone could have bought this house, added 2 more stories on it, not disturbed 2,500 feet, and none of that would occur. So this is actually a property that will be improved, whereas the ones around will not be.
That's a good
To
point.
the extent of the law required for handling stormwater these days, which sounds like the building code gets more strict every year. So,
Okay.
Madam Chair, the speaker, what was your name again?
Ms. Thompson?
Thompson? Okay. Thank you.
And then our next speaker, and I'm sorry, what's your last name?
Answer with Stanley Martin.
Sir, I was right, okay.
Just 2 things to address this lady's concerns. So not only do we have to treat downspout and water runoff, but we also have to treat the entire driveway. So the driveway has to be what they call a BMP, or a stormwater management device. So there's nominally a foot of stone, you've got the porous pavers, so that runoff, if you look at the driveway, and in fact, if you were in the pictures that we submitted, there's a concrete surface that goes along kind of the back of the house. So all the water that hits there, there's no friction. It's just going to run off that concrete, whereas we'll have more, I'll call it grassy area, which creates more friction, which will slow down the water runoff. It's just another nuance, so to speak.
Okay. Questions? I have a question of the applicants. How does any delivery service ever find your house? Seriously, I mean, I live on a corner lot and it's only 2 different streets they can't figure out. This is 3.
It's the shape of home plate.
Oh my gosh. That's phenomenal.
Yeah, there are a lot of converging streets right there.
That's
Well,
the
good
funny
luck
part.
with
This
that.
is not actually a corner lot either.
Is that right?
It's just North Nottingham Street that makes that curve.
Wow, not a corner lot.
That's
Well,
that's
you're
a
lucky
legal
it's not a
fiction.
corner lot.
That's called a legal fiction.
Yes. Oh my gosh.
Yeah.
Wow. Okay. Any further discussion? Questions? Are we ready for a motion?
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10855-13-UP1, subject to conditions listed in the resolution.
Second.
Okay, who's seconding it here? Mr. Russell. I heard your voice first. Okay, yeah. Made by Ms. Freshman, seconded by Mr. Russell. All in favor?
Aye.
Aye.
Opposed? Carries 4-0. There you go.
Photo finish.
And you all should have 2 packets of meeting minutes this time, because in the September meeting, you all decided, or actually, sorry, the October meeting, you decided to defer the September minutes since there are only 3 members at meeting, 2 of which were here last time. So you have 2 sets of minutes in front of you. It should be September and October.
Madam Chairman? I will move approval of the September 12th minutes.
Second.
Okay, Ms. Freshman and I were not there, so I guess we need to abstain. So, yeah, so all in favor?
Aye.
Abstaining? Okay. So can we pass that with 2 people?
You need 3.
I guess it's
Bring them back next month.
2 to 2 is not a quorum in this situation, unfortunately. The tie
I
fails.
figured that caused the problem. I should make the motion, right?
We'll try for December.
Yes, okay.
Okay, how about October?
Wait, but somebody is not going to be here in,
Yeah, me, but it doesn't matter because I
because you
wasn't
weren't
there.
present anyway.
Oh, so the
Right.
3 people.
Yeah,
Yes.
we can approve this month.
God willing, yeah.
If we all show up.
The 10th of December?
Yes.
Wow, so we
Tuesday.
can,
It is a Tuesday meeting, by the way, as opposed to every Thursday we've had this year.
Thank you for making that, reminding me of that.
I was going to send you one either way. I will.
okay, so should we go ahead with the October minutes?
I move the adoption of the October 10 minutes.
Second.
Okay, moved by Mr. Smith, second by Ms. Freshman. All in favor? Aye. And abstaining, so it's 3 to 3.
3 to 1.
3 to 1. 3 to 0 to 1.
3 to 0 to 1.
Oh, I'm sorry. That's correct.
Like baseball, you got to get the.
Well, that's more like hockey going into extra periods, and then it's still resulting in a tie after the shootout.
Ridiculous. Okay, so we'll keep September's. So is there a motion to adjourn?
I move adjournment.
Second? Okay, all in favor? Aye.
There are very few sports that allow for ties anymore.
Skippy.
True.
Wrong to do that. Excellent.